Justice Kavanaugh?
In response to Justice Sotomayor's question, you have Taft and Scalia, right? It's not too shabby.
I think those are outstanding jurists, and with respect to Justice Scalia in particular, one of the greatest jurists in the history of the court.
I thought your two exceptions that you've had a lot of questions about, but I thought the two exceptions, the categories were, one, the Federal Reserve, based on history and tradition and function, and the other were the non-Article III courts, which starts in Marbury. Marbury itself discusses this. Taft discusses Marbury at length in Myers on this exact point of non-Article III courts being different. Taft leaves that open, right, in Myers. And so for Court of Federal Claims, tax court, the DC local courts, you mentioned this at page 23 of your brief, it would seem to me that Marbury itself says that is a line that distinguishes the non-Article III courts from the position that you're taking here. I know you may not agree with that, but is that a principled, sensible line we could draw?
Certainly it is something that the court could look at. I don't want to take a position on them. To be clear, I am not taking a position on whether that line is valid, but certainly there are arguments that could be made and debated in an appropriate case about where those lines should be drawn. And you do, I think, correctly reference both Myers and Marbury itself as teeing up some of those issues.
There's been debate about Marbury. Was that about DC or was that about judicial office? But I read it to be some of both, so for what that's worth. Why did no president challenge this structure from 1935 to 2025? We've had a lot of presidents who've had very strong views of Article II, yet for 90 years it stood not directly challenged. Why do you think that is?
It'd be speculative to answer that. I mean, one reason might be that presidents are fairly comfortable with taking away tough political decisions. So as the court has said in multiple cases, I believe, one president cannot bind the hands of its successors, and the president, there's a kind of responsibility that goes with the authority here. The president sometimes may have a political incentive to allow tough decisions to be outsourced, so to speak, to agencies that he doesn't have direct control over. However, our constitutional structure dictates that the president cannot do so. He cannot bind the hands of its successors, or the encroached upon branch cannot consent to the encroachment, and therefore disrupt our constitutional structure.
One thing you've said, but I want to make it crystal clear, that overruling or narrowing Humphrey's executor would not threaten the existence of these agencies, but only would alter how the heads of those agencies can be removed, correct?
Correct. They'd be politically accountable to the president, and this court has in 3 different decisions addressed these kinds of broader implication, severability arguments, and come down there.
The way we've done it is to sever the removal restriction, not to destroy the agency, correct?
That's exactly right.
On stare decisis, you used the word dangerous, I think, in your opening about the independent agencies. One of the things we consider are not only how wrong it was and reliance interests, but the real world impacts. And I think just give you a little bit to explain why you use the word dangerous when talking about independent agencies, if I heard that correctly.
And maybe to return to the exchange I had with Justice Kagan, the real world consequences here are human beings exercising enormous governmental authority with a great deal of control over individuals and business, small and large businesses and so forth, who ultimately do not answer to the president. That's a power vacuum. The president is answerable to the voters. They have no boss. And regardless of what happens, when there's a power vacuum, somebody's going to come into that power vacuum. So is it Congress that many commentators have noted actually exercise substantial control over these independent agencies through budgetary functions and through oversight functions? Is it industries engaging in industry capture of the agencies? The point is that power vacuum should not exist in our constitutional structure because, as Madison said, there's a line of accountability, a chain of dependence that runs from the officers to the president, and he's answerable to the community, which is the voters, every 4 years.
I want to return to what Justice Kagan and Justice Gorsuch were talking about with you in terms of the bargain. And I think broad delegations to unaccountable independent agencies raise enormous constitutional and real-world problems for individual liberty, as you just mentioned. I've obviously said that many times in prior opinions. I thought one aspect of that we've taken great steps to correct has been the major questions doctrine over the last several years to rein in what Justice Kagan was talking about, these broad delegations, to make sure that we are not just being casual about assuming that Congress has delegated major questions of political or economic significance to independent agencies or to any agencies for that matter. You want to speak to the major questions doctrine and how that fits into your answer?
Suffice to say that the major questions doctrine is not a substitute for the president's removal power. It may have done some work in backstopping the fact that we do have these independent agencies without a political discipline, but the president's removal power is what is dictated by the Constitution, that the president must have the power to control, and that these agencies, the one who has the power to remove is the one who is the person that they have to fear and obey.
Sorry to prolong this, but on your second question presented, I just want to touch on that quickly. This is about the reinstatement argument that you make. I have some real doubts about that argument. We don't need to reach it, of course, if we agree with you on the first question. I have some doubts about that because that really would be an end run around the exceptions you had identified earlier for the Federal Reserve or for the non-Article 3 courts. In other words, you could just remove those people, and so long as you continue to pay their salary, you wouldn't have to reinstatement. That strikes me as really destroying the categories that you had identified as potential exceptions. So I'm concerned about your reinstatement argument on question 2, and just want to give you a chance to address that.
Maybe I could just say two things. I think that this court in its Wilcox-Harris stay opinion said something very telling. It's not binding on this issue, but it's very persuasive when it talked about how when it comes to the balancing of harms, the injury to the government from being forced to take back into the fold an executive officer that the president's really already ejected from the fold outweighs the interest of even a wrongfully removed officer, as I read that sentence, wrongfully removed officer from continuing to exercise their statutory authority.
Don't you have a problem again here with Marbury on recognizing mandamus? I mean, I know a lawyer never wants to hear you have a problem with Marbury, but I think you have a problem with Marbury.
Well, I think the fact that it's a judicial officer there doesn't raise all these separation of powers
the other side says that's completely gerrymandered answer to the, yeah, but what's the principle on page, what is 43?
The principle, I think, is the separation of powers, right? Because these removals of the executive branch, if you're removing a judicial officer, it just doesn't raise all these issues. And that's why the answer to that concern when it comes to Article 3 courts is not, oh, the president doesn't have removal power. It's that, are these Article 1 or are these Article 3? If they're in Article 2. If they're in Article 2, the president has control. If they're in Article 1, then it may look very different.
Thank you.